to the Binary Agora. In this series, we dive deep into the world of legal tech, breaking down its challenges, its innovations, and real-world impacts with insights from top researchers. And today, I will be addressing the developments surrounding a different kind of regulatory instrument that we have not talked about yet in the channel, the Japanese Smartphone Software Competition Promotion Act, for short, SSCPA, or the Smartphone Act. And as we'll see throughout the episode, the SSCPA seeks to tackle similar problems as the DMA, but in a different way. To provide a bit of context on the SSCPA, it was promulgated in July 2024 when the Japanese legislature introduced the law to address the concerns that the Japanese Competition Authority, so the Japanese Fair Trade Commission or JFTC, had already identified within its market study report on mobile operating systems and app distribution, which it issued in 2023. In the report, GFTC identified the existence of a clear duopoly in terms of the catering of operating systems, since nearly half of Japanese citizens use Android, 53%, and the other half operate on smartphones running on iOS, so 46% of citizens. Only 4.2% of users rely on other operating systems different from Google's or from Apple's. Thus, this brings them the capacity to refuse to compete on the merits because the lock-in effects that their operating systems remain high, and therefore no new entrants pose a credible threat to their position in the market. And this is the reason precisely behind the fact that the SSCPA only focuses on smartphones and not on other types of devices such as PCs or tablets. Building on these reports, the GFTC passed the SSCPA by introducing obligations and also measures that the regulatory targets must comply with. In a similar vein to the European DMA, the SSCPA introduces an asymmetric regime by which only a few operators in the market will be subject to the regulation's obligations. The GFTC designates those regulatory targets termed in the Smartphone Act as specified software operators, and it did so in March 2025. Shortly after that, the GFTC also specified the bulk of these substantive provisions applicable to these regulatory targets, so the SSOs, within the SSCPA on its Mobile Software Competition Act guidelines by setting out first the goals, the measures, and also the implementation that it intends to achieve via the regulation's introduction. This is precisely the focus of this episode, since those obligations will come into effect in Japan starting in December 2025. In the meantime, before we get into the nitty-gritty of it all, I also very much recommend a piece that I co-authored with Sang-Yoon Lee last year on the goals of the SSCPA and how we also foresaw enforcement to unfold in the future. Also, it's available in through our competition law blog, and you'll also find a link to the post in the description. Moving forward, as a general introduction to the CCPA, it does not really pose such a stark contrast to the current enforcement that the JFTC has been deploying in digital markets. As opposed to the DMA, which runs to the woods in its overlaps with competition law, the CCPA shares much more of its of the underlying premises with Japanese antitrust, since it seeks to attain a fair and free competition in the markets where these specified smartphone software operators do their business. And in this sense, the SSCPA engages directly with a broad notion of fairness comprising three different tenets. First, the redistribution of the allocation of surplus within the mobile ecosystem, depending on the efforts of each of the business users dedicates to it. Second, it also prohibits certain use of terms that may unfairly burden these same business users. And finally, ensuring that these business users are treated equally and also fairly across the whole mobile ecosystem. By trying, therefore, to restore the fairness in these markets, the Japanese legislature seeks to rehabilitate the competitive dynamics of these markets. Since both the SSCPA and the enforcement of antitrust in Japan share common roots, within the guidelines of the JFTC already recognizes that there is a clear overlap between the two, so the CCPA and Japanese antitrust. Both can be applied to the same sets of cases, but the SSCPA is considered as a lex specialis with respect to the Anti-Monopoly Act, since it laser focuses on the market surrounding smartphones and their many applications. Despite or precisely given the overlap between both regarding especially their objectives, the CCPA deviates from the DMA's institutional structure in a fundamental way. The regulatory targets must not necessarily comply with all obligations established via the regulation. Falling within the scope of the application of one of the provisions of the SSCPA does not necessarily entail that the regulatory targets, the SSOs, will implement measures to comply with them. As a matter of fact, SSOs can put forward legitimate reasons in the fashion of objective justifications by which they need not to comply with an obligation. Those justifiable reasons span several areas, including cybersecurity, also the protection of information of smartphone users, safeguarding the youth who use these devices, and the necessary protection of gambling and other criminal activities conducted using smartphones. The guidelines introduce this closed list, aside from those objectives which can also be further specified via a cabinet order, as potential justifiable reasons for the SSO's exemption from a particular provision. In the end, this will mean that not all SSOs comply in the same way with all obligations. Against this framework, the SSCPA also operates a reversal in the burden of intervention by establishing that all designated SSOs must submit a yearly compliance report before the JFTC. This obligation is much wider than the regulatory efforts required by DMA gatekeepers, since SSOs must also provide evidence that supports, for instance, the finding and the recognition of a justifiable reason. The designated SSOs by the JFTC are both Apple and Google for 4 types of relevant service categories, the equivalent of core platform services, amounting to 8 designated services, including Apple's and Google's operating systems. SSCPA calls them basic operating software, as well as app stores, including the duopoly's usual suspect, plus Apple's iTunes, which is quite surprising to see designated. According to the 2023 report we were talking about earlier, most consumers using music distribution services such as iTunes or Spotify always enjoy them on a native app, that is, on an app developed for one particular operating system, normally available for download in both the App Store or Google Play. On top of that, the report also concluded that the playing of music is an experience on different connected devices with respect to smartphones, which has been hugely undermined by the restrictions placed by the too many operators of the operating systems. Lacking any additional supporting evidence, the GFTC's designation of iTunes results in the clear dismembering of Apple's complementary services to its App Store. However, the main point where I disagree relates precisely to its categorization as an app store, which I am not quite sure fits the regulatory structure of the SSCPA, since the offerings of iTunes Store are basically songs, and they really are dissimilar to the offerings of, for instance, app developers in the form of apps, which can trigger also further relationships with both consumers and business users. Aside from that, the two main browsers operating on a smartphone and in any other device, to be honest, as well as Google's search engine, also remains designated as SSOs, and thus they will have to start complying with the SSCPA come December 28. In the DMA, Articles 5 to 7 form the flesh and blood of the EU's efforts in addressing these objectives of contestability and fairness in digital markets. In the SSCPA, however, we can distinguish two types of obligations imposed on designated SSOs. On one side, Articles 5 to 9 establish the prescriptive content of the regulatory targets obligations. In other words, these provisions contain everything that they must refrain from doing, such as, for instance, using improperly acquired data, unfairly treating different app developers, or engaging in self-preferencing. Not all of the provisions apply to all types of relevant services, as was to be expected, and in a similar fashion to the DMA. For instance, the prohibition on self-preferencing contained in Article 9 only applies to SSOs designated for search engines, whereas the scope of Article 6.5 of the DMA includes other CPSs. Similarly, Article 6 of the CCPA, which could be assimilated to Article 6.12 of the DMA, applies to designated SSOs of basic operating software and app stores. That is, discrimination in the form of imposing restrictions on conditions on third parties may take place in both contexts. On the other side, from those prescriptive obligations under Articles 5 to 9, Articles 10 to 13 of the SSCPA introduce positive obligations upon the designated SSOs to adopt meaningful measures to enhance transparency in the business relationships of these ecosystem holders and third parties, for instance, via Articles 13, and they also tend to enhance consumer choice in providing more opportunities for switching default settings and tools, such as in Articles 11 and 12. When faced with the challenge of translating these obligations into practice, we cannot expect from designated SSOs that they simply comply with all of the 9 obligations when their services fall within the scope of their application. There's simply more to compliance with the SSCPA than that, since the application of a given provision does not preempt the finding of a violation of the SSCPA when the designated SSO does not implement a provision. As opposed to the DMA, the SSCPA is concerned with the effect that the conduct of the SSO provokes on competitors and markets in general. That is the reason behind the fact that the guidelines clarify that violations of Articles 5 to 9 require a high likelihood of harm being caused to competitors. When conducting its assessment to impose sanctions due to a lack of compliance with the SSCPA, the JFTC must also observe the real-life repercussions of SSO conduct, taking into account, for instance, their effects and also the extent to which they are capable of restricting competition, even if competitors are not present in the market. So the factors the JFTC will take into account to establish this degree of the likelihood of difficulty to provide services will be assessed based on the nature and the duration of the conduct, as well as the degree of impact on third parties in hindering the exercise of their rights abiding by the regulation. In this sense, the SSCPA is a more flexible regulatory instrument than the DMA because it also provides great leeway to the JFTC to accommodate the legal requirements contained into the market reality. However, the fact that it is so flexible does not directly entail that the regulation is directly unmanageable. The SSCPA applies clear restrictions to the free-for-all approach of justifiable reasons. First, the designated SSO cannot rely on any other reason not explicitly mentioned by the JFTC in its guidelines, including this list we already pointed out before, including cybersecurity or the protection of personal information. Second, the guidelines also set a clear proportionality test the SSO must conduct before arguing that any of the justifiable reasons apply. The SSO is forced to demonstrate the necessity of the restriction, i.e. the lack of its abiding by a particular provision, as well as its reasonableness, i.e. that the restriction constitutes the less restrictive means to achieve the objective, which also plays to the same tune of the security and the privacy exceptions that the DMA establishes in some of its provisions, such as its vertical interoperability mandate. And now I will turn to the specific details of the guidelines by providing a few examples of the the SSCPA's impact in real-life situations that have already unfolded in the midst of the market surrounding smartphones. For instance, you may have heard that Elon Musk took legal action against Apple because he argues that the App Store makes it impossible for other AI providers different from ChatGPT from ranking first on the top free app section for iPhones in the US. His own XAI app normally ranks 5th, whereas Google's Gemini chatbot sits at the 57th position, despite that OpenAI's ChatGPT ranks at the top of the results every single time. Article 6 of the CCPA tackles precisely these types of situations where SSOs conduct a review concerning individual apps and provide unfair treatment without reasonable grounds. The SSCPA defines such unfair treatment as that where the SSO treats third-party app developers differently without reasonable grounds, either compared to the designated provider itself, i.e. with regards to its own goods and services, in this case apps, or where certain third-party app developers are treated differently from others. For instance, the guidelines clarify that if the purpose of such treatment is to, for instance, pursue operational rationality and results in cost reductions that are not returned to smartphone users or third-party app developers, it is generally determined that there are no reasonable grounds. In this same sense, SSOs can also impose restrictions and limits upon third-party app developers when reviewing their apps. But they must also ensure a certain level of consistency and be aimed at, for instance, improving the overall quality of the App Store. Although the nearest equivalent we can find with respect to Article 6 of the CCPA is Article 612 of the DMA, the guidelines provide a fully fledged account of the provision and clearly define what unfair treatment is in the context of the regulation's application. When the guidelines flesh out each of the provisions from 5 to 9 and also from 10 to 13, they provide an overview of the main tenets to each application and also some hypothetical scenarios where the SSO incurs in a violation of the provision, and it also provides some of the measures that the SSOs may implement to compensate for the overall harm of these types of conduct. Relating to the former, the guidelines point out that such a hypothetical scenario will be given when app rankings within the App Store, based on, in principle, objective metrics such as download counts or reviews, do not display the apps of third parties or rank them in a lower position than their actual deserved ranking. To counteract these types of effects, the guideline establishes that the SSOs must impose measures both inwards and outwards with respect to their conduct. First, the SSO must confirm internally whether unjust discriminatory treatment has been taking place and eliminate those instances where it happens if that's the case. And second, it must also provide evidence and also explanations to third-party app developers on the reasons why its treatment remains fair. Thus, the SSCPA imposes not only an obligation of disclosure upon the SSOs with respect to the JFTC, but also regarding their trust relationship with their downstream competitors as well. From previous experience with the gatekeeper compliance regarding the DMA, we have also seen conduct spanning the unfair treatment sanctioned by Article 6 of the CCPA. The provision's scope of application comprises SSOs for App Stores and basic operating software. A good example of the latter would be the restrictions that Apple has imposed upon alternative marketplace operators to run their own app stores on iOS by, for instance, forcing users to first enable the installation of alternative app stores via their settings, and they must also visit the provider's website to install the alternative offering. Once the user presses the install button, they will be redirected to the screens that you'll see now on the slide, where fair warning is given on the risks posed by alternative app stores. Although this could well fall within the scope of Article 6, the guidelines clarify that if Article 7 comes into play, because it also explicitly prohibits SSOs from prohibiting smartphone users from using alternative app stores or establishing technical restrictions to make it impossible to provide them. As well, the latter will take precedence over the former. Article 6 is most concerned with restrictions relating to the developer's operations within the App Store. For example, the SSO cannot impose parity clauses on pricing, and Article 7 addresses particularly the alternative means of app distribution from the operating system perspective. The unclear aspect about Article 7 precisely lies in whether it also imposes further obligations on the SSOs to try to enable sideloading to be effectively realized on the operating system, to the extent that it is also an alternative means to try to obtain apps. Following the example of Apple's imposed terms and conditions once the DMA entered into force, and notably via Article 6.4, you'll perhaps remember the restrictions that the gatekeeper also introduced to alternative marketplace operators in the form of the well-known core technology fee. Basically, the fee accounts for the installs that an alternative app store manages to achieve, and charges have €1 for each annual install. If we turn to Article 7 of the CCPA, it does not allow SSOs to establish technical specifications that make it really difficult to provide alternative app stores. Notably, it takes into account technical constraints, contractual terms, or also excessive financial burdens on other businesses. To assess whether the financial burdens make it excessively difficult for the alternative app stores to operate on a level playing field, the guidelines signals that the JFTC will have to evaluate the competitive conditions between the SSO's own app store vis-à-vis the alternatives by comparing the fees applied to third-party app developers for using their own app stores to those charged to the alternative providers. To demonstrate compliance with the provision, the guidelines recommend that the SSO posts, for instance, the fees that alternative providers will have to face, alongside a clear explanation on how the level of the financial burden is reasonable, bearing in mind the comparison that we have just highlighted. To finish our recap on some of the provisions introduced by the SSCPA, we must necessarily also take a quick glance at the self-preferencing prohibition under Article 9. According to the guidelines, the SSOs of search engines cannot give preferential treatment to their own goods or services over competing goods or services without a legitimate reason when displaying search results through the SSO's search engine. Article 6.5 of the DMA may be a bit wider in terms of the services it may touch upon. The SSCPA's prohibition of self-preferencing is much wider in terms of the interpretation of preferential treatment, since it comprises nearly all aspects involved when a user queries the search engine. For instance, it comprises the arbitrariness of the search algorithm settings, or also the establishment of separate sections when displaying results to a smartphone user, and also the expected unfair or potentially unfair or discriminatory treatment that the search algorithm itself administers to the downstream competitors of the search engine operator. Additionally, Article 9 of the CCPA is equally equipped to address those scenarios where only data related to the SSO has been crawled and indexed into the search algorithm, so that the outputs of the search queries always result in detriment of the downstream competitors. At the start of the presentation, we pointed out that justifiable reasons could exempt the SSOs from complying with some of the provision, but Article 9 of the SSCPA adds a different concept: the existence of a legitimate reason for performing this type of conduct. The SSO cannot simply argue that the search algorithm and its discriminatory treatment demonstrate the most desirable business route for itself. The improvement of the search algorithm's quality must be concretely and also specifically demonstrated by the SSO via tests conducted directly with smartphone users, so that both the JFTC and also third parties can assess whether those reasons hold true or not. And once more, the guidelines also prompt at the idea that it would be desirable for the SSO to indicate the main parameters of its search algorithm to its downstream competitors and the reasons for its administering of a different treatment, which can in on itself pose several conflicts of interest in the SSO's role as both a search engine operator and the undertaking competing in the downstream markets depending on search. All in all, so if one looks closely at the guidelines issued by the JFTC to try to narrow down also the expectations surrounding the SSCPA's interpretation, a clear conclusion results from it. Legal standards on how to disintermediate gatekeeper or SSO power from the most powerful digital platforms in the world waver and also transform depending on the jurisdiction that we look at. On top of that, the GFTC does not really keep purposely ambiguous in terms of the regulatory intentions that it bears, nor the transformations that it expects to see in the market, unlike the European Commission in interpreting the DMA's provisions. That's really a good sign, but the regulation of digital platforms does not come without its cost, especially bearing in mind the overlaps in regulated conduct and regulatory targets paired with the enshrining of distinct legal standards. And the question still remains as to who will, in the end, assume such a cost. And that's really a wrap for this episode of the Binary Agora. So if you have any thoughts or feedback on the video, please drop a comment below. And as a last minute recommendation, I also wanted to present the Binary Agora's spin-off on LinkedIn, the DMA Agora, where I also document and review the latest news on the developments around regulation. I'll include also a link in the description below. Bye bye.